So in raising this issue with the Corporation Council, for Wayne County, sorry, you're right. So let me go back. So in having those discussions, they quite frankly, turned my words on myself. Margaret Flanagan, who is the Corporation Counsel for the 3rd Judicial Circuit Court of Michigan, actually sent a notice, waited almost 3 weeks from notification, sent a notice on Monday at close of business stating that the judge would not be here. So quite frankly, they say that, right? And having those discussions. And so this morning, I then followed up with the following points. This letter from you confirms that you and Judge Snow are in receipt of the subpoena issued via the unanimous vote of the Taylor City Council. Previous discussions with both you, your staff, and Judge Snow's staff well before the 14-day notification period further confirms the same. The unanimous vote of the Taylor City Council to subpoena Judge Snow per section 6.16 of the Home Rule Charter of the City of Taylor, as authorized by the State of Michigan, compels Judge Snow to appear before the Taylor City Council on Wednesday, August 7th, 2024 at 6:30 p.m. To wit, section 6.16 of the Taylor City Charter states, the council shall have the power to hold hearings on any matter within its province, and to compel by subpoena the attendance of witnesses and the production of books, papers, and data in any hearing pending before it. Such subpoena may be served by any person of legal age. Each witness shall be entitled to receive the same fees for attendance as is provided by law for the payment of witness fees in the Circuit Court of the County of Wayne. The council may by ordinance prescribe the method to more effectually carry out the foregoing provisions. Any person who, having been personally served with subpoena, willfully refuses to comply with the same may be punished with a fine not to exceed $500 or imprisonment not to exceed 90 days or both in the discretion of the court. The next statement was, the public hearing is not intended to re-adjudicate the original case, but rather to publicly examine the potential Open Meetings Act violation due to Judge Snow's actions, which is within and remains in the province of the Taylor City Council. The Open Meetings Act is prescribed by the State of Michigan Constitution. 7. The City of Taylor is bound by the Open Meetings Act, and we adhere to it in both spirit and letter of its intent. 8. The people of the City of Taylor have a right to know that Judge Snow, through her actions, violated the separation of the branches of government and via a legal order compelled the majority of the City of Taylor Council to appear before her. 9. Judge Snow, in her callousness, compelled the majority of the Taylor City Council to sit in a courtroom, not understanding this constituted a need to conduct simultaneously a court hearing and a Taylor City Council meeting. 10. Note that failure by Judge Snow to attend the public hearing before the Taylor City Council may be punished with a fine not to exceed $500 or imprisonment not to exceed 90 days or both at the discretion of the court. And then finally, number 11 was, as this is a legislative body, I cannot predict if the majority of the Taylor City Council will or will not approve such legal remedies if Judge Snow fails to follow the legal subpoena
understand and I did appreciate, honestly. So, what are our next steps?
Well, the two, if you'd like to, there are two proposed, two possible motions. Certainly anything else that the council may come up with. Does everybody have a copy of that? So one potential motion would be a motion to find Wayne County Circuit Judge Martha Snow in contempt and in violation of Taylor Charter Section 6.16 for failure to appear at tonight's City Council meeting